Great, so I'll start. So I'm Lee Curtis, and I'm a chartered trademark attorney. I'm going to talk about IP. My knowledge is very much on trademarks, brands, and designs. I'll touch a bit on patents, but I'm not a patent attorney. We have a large patent practice in our firm, but and if you have any specific questions on patents, I can refer you to someone. But I know the basics of patents. So I just thought just to emphasize why IP is important. This is a quote from the ex-CEO of Quaker Oats. I think this is important for two reasons. One, it just emphasizes that intellectual property, it's intangible, but it's a property right, so it's an asset like any other asset. And John Stewart basically said if you were making a decision between physical assets, such as laptops, buildings, books, etc., or the brands or trademarks from their business, and obviously with Quaker Oats, most of the value is in the brand, he would pick the brands and the trademarks over the physical assets, and he would come out much better than you in that division of assets. So this is why IP is important. I'm going to talk about there are basically four different types of IP. Trademarks, which are basically badges of trade origin. So they distinguish one product from another product. So for example, Coca-Cola would distinguish one sticky beverage from another sticky beverage. You don't necessarily need to know who's behind the product. You just need to know there's a defined undertaking or undertakings. Designs, they concentrate on the look of the product. So how a product looks. So for example, with an iPad, it's the physical appearance of the product, but trademarks and designs do overlap. So if you have a logo, that could be subject to both design protection and trademark protection. And then we've got copyright. Copyright protects basically literary works, dramatic works, artistic works. I think people think, oh, copyright is about grand artistic statements, but you can have copyright in terms and conditions, websites, anything which is novel or something new, and you can have very narrow copyright, and it's often, I've had clients who just, have either copied or have had their terms and conditions copied, and you just need to be very wary that potentially there is copyright in such works. And so, for example, a logo, that would be protected again via artistic copyright if it's novel. And then we've got finally patents, which I'll have one slide on patents. That's the invention behind a product. So basically how it works, and you have to have an inventive step. So if you think about an iPhone, that will be protected by multiple forms of IP. So you'll have the Apple logo, the Apple word mark, which is a trademark. You'd have the design of the product, how it looks. That might be unregistered and registered. You'd have copyright again, potentially in the literary work on the phone. And then finally, you'll have patents and how it works. And I'm more than happy to answer questions as we go along. So just to talk firstly about trademarks, and I'm concentrating on the UK at the moment. Trademarks can be protected via common law. Basically, the legal systems of the world are broken up into two different systems. You have the common law system, which is basically, I always say, the United Kingdom, anywhere that was part of the British Empire, speaks English. So that would include the US, Canada, Singapore, Hong Kong, Australia, New Zealand, South Africa. That is, common law is basically English common law. And all of those legal systems are based on English law. And then you've separately got what I would term as the Roman law systems, which are places like continental Europe, Russia, China. There's no such thing as common law. And the important distinction is with trademarks in the common law countries, such as the UK and the US, you can build up rights simply by using it. And what you're protecting there is the goodwill. Legally, it's often quite hard to define what goodwill is, but it's defined in case law as the attractive force that brings in custom. It just needs to be more than trivial. So your local corner shop would have goodwill because people know to go there. They know there's a certain trader there who provides a certain service or a product. So it can be very small amounts of goodwill can be protectable. Then we've got to show, if you're going to enforce so-called passing off rights under common law, you also need to show misrepresentation. So you need to show consumers are deceived. Now that would include confusion, just simple confusion. Now misrepresentation, you don't have to prove fraud to show misrepresentation, although the judges have said if you can show fraud, that you've deliberately gone out to mislead consumers, that helps your case quite a lot. And then finally, in what we call the holy trinity of passing off, you've got damage or the likelihood of damage. So if you can show you've got goodwill, a protectable asset, you can show that people are confused, then usually damage or a likelihood of damage follows on automatically. And just to give you an example there, that's Moroccan oil, quite a well-known oil, and there would be goodwill in the packaging and the look, also in the name, and I think that was Aldi brought out Miracle Oil, but this shows some of the weakness of passing off. Aldi actually got away with it based on the relatively small differences in the marks, and what I'm trying to say is you don't necessarily have to register a trademark to use it. You can get trademark rights in the common law countries via use, via goodwill, but it tends to be of limited effect and it can be difficult and costly to enforce. So now I'm going to talk about registered trademarks. And what registered trademarks, basically every country in the world has a trademark register. There's very few who don't now. And what a registered trademark, at least in the UK, would protect is if you register your trademark, you go off to the UK IPO, the United Kingdom Intellectual Property Office, you put in your trademark application, you have to define what your trademark is, and that might be a word, a logo, and then you have to define what you're going to cover, the goods and services, and there's 45 classes, you have to define a specification. And if you can get a trademark registration, you can stop the use by a competitor or not a competitor of an identical mark on identical goods or services, but also you can stop them using it on similar mark and similar goods and services if there's a likelihood of confusion. Now you may ask, what is a similar mark? Well, the courts define it via phonetics, how it sounds, concept, what it means, and visual, how it looks. Then they lump that all together and they say, would there be confusion? Judges have said that this doesn't protect morons in a hurry. It has to be a defined, reasonably circumspect consumer. And are they likely to be confused? But you need to be aware that with reputable trademarks, and that would include the Coca-Colas of this world, but it would also include brands which are relatively well known in a certain market, they can stop use on dissimilar goods and services if you can show use without due cause, and if it detracts or puts down on the distinctive character of the trademark or is detrimental. So with reputable trademarks, if you're out there and you see a reputable trademark, you just need to be very careful not to go too close to them. If you get a registration, you don't have to show use for 5 years. But after 5 years, if you haven't used the trademark, basically someone can go in and cancel it for non-use. And also, what the registration is useful for is what we say, send in nasty letters, basically. So if you have a trademark registration, it's much more easier to enforce and to threaten someone than goodwill or passing off, because if you've only got goodwill and trying to enforce it via passing off, the natural retort of the infringer is prove you've got goodwill, show all your use. Whereas with a registration, you've got a trademark certificate from the UK IPO. Now, all of these are jurisdictional, so the EU's got their own register, US has got their own register, Canada's got it, Russia's got it. So they are slightly compartmentalized, but there are international systems for registration. And the other thing is, if you do get a trademark registration, you can use the R in a circle to define that it's registered. Just don't use an R in a circle when you haven't got it registered, because it's a criminal offence, which is enforceable by trading standards. I don't know anyone who's gone to jail or been fined for this, but you just need to be be wary. Some people say, can I use the TM? TM legally means nothing, and you see it on trademarks, signs which are obviously not registrable. But if you haven't got registration, then by all means, put the little TM next to your brand or a sign. There we go. So what can be registered? Basically anything can be registered apart from a smell. So the main things are words and logos, but you can also register letters, numbers, shapes. So the Coca-Cola bottle, the shape of the Coca-Cola bottle is a registered trademark. You can register packaging, so packaging of a perfume bottle. You can even register sounds, so Intel and Microsoft would have registered the sound when you open up the software. Holograms. Once upon a time I used to act for the Royal Bank of Scotland, and they owned Churchill Insurance, and they were thinking about trying to register the nod of the Churchill nodding dog to protect and stop other insurance companies bringing out similar nodding dogs in their thing. Asda have in the past registered tapping your backside in their adverts. Now, why can't you register smells, which is the only thing, is when you have a trademark, you have to define it. And the courts have said with smells, everyone has a different nose, and it smells differently to different people. And there's no easy way to signify a smell, in contrast to like a musical score, which can be read. They just say, oh, you could put a smell in the patent office or the UK IPO, but it would degrade over time. So really the only thing you can't register is a smell. And for a shape, it shouldn't have solely for a technical purpose, and also it shouldn't give added value. That's a hard term to define, but it's meant to stop things like jewelry being registered as trademarks, which are very much the value is in the product, not in the brand. Now, to give you an idea on things which can be protected, I act for WeBuyAnyCar.com, and what can't be registered inherently at the start is a term which is descriptive. So, for example, you can't register the term car for cars, soap for soaps, coal for coals, because regardless of the amount of use, you're never going to educate the public that that's a brand. Now, at the start, We Buy Any Car was inherently non-distinctive, because that's what the business did. It did buy literally any car. So what we registered at the start, and this may be for some people who've got borderline descriptive marks, is we registered the combination. So the little car logos and the combination of the colours. And that was deemed inherently distinctive because of the combinations of colours in cars. Then we registered without the cars, then we registered the word, then we registered the word without the .com, and then finally we registered we space buy space any space car. Now we only got that based on evidence of use. They have a turnover of about 800 or 900 million now. And why we were trying to go down into the core element, the word element, is to stop things like AdWords, use on metadata on websites. And you're always trying to concentrate on the core element of your brand, and to try and define it. It's like a property right as much as possible. So I just thought I'd give you like a pop quiz on distinctiveness. So does anyone, just to give you, do you think the top mark is inherently distinctive? No?
Maybe if you created the typeface.
Maybe, yeah.
Copyright.
How about the second one, Tissue Deluxe? Do you think that's distinctive? Is that protectable? Inherently, ignore use. Is it right off the bat distinctive?
I don't.
What are you speaking about? The
Tissue Deluxe.
Like, I mean, the design. Is that
Well, trademark is like a word.
or just the
I'll explain in a minute.
Makes it
Yeah.
a little bit different.
How about lacto-free? I haven't really talked about lacto-free, but do you think the terms do you think that's distinctive? Is it deceptive for certain goods? And then,
Not a statement.
yeah. Then we've got have a break. Could that be inherently distinctive, or would it have to have use?
You would have to have use.
Yeah,
Kit Kat maybe.
good one. The first one is non-distinctive just because it would never really be seen as a trademark, just because it's a relatively well-known symbol. Tissue deluxe would be deemed descriptive tissues because it's laudatory. It just is a laudatory term for good tissues. Lacto-free would be held to be deceptive for anything with lactose in. So the registry would object to, and if you then try and spin it the other way around, you would get caught by descriptiveness on for lactose-free goods. And then have a break, yeah. The only way have a break got registered was based on massive evidence of use. They never actually use have a break on its own, but the courts accepted that when people say have a break, they immediately say have a Kit Kat. But you had to provide a lot of evidence that that's what the public understood as. So we've talked about distinctiveness and descriptiveness, but you also have to make sure that your trademark application doesn't conflict with anything registered rights of other people or indeed common law rights. So you should do pre-clearance searches just to see if you're free to use. You can do basic searches for free on the UK IPO website. So I'm not saying they're perfect, but you could at least pick up bang on identical marks. You also have to think, am I offering an identical or similar goods or services to the registration? Also in your mind think, is there potential for consumer confusion? And go back to the test, which is about how does it sound, how does it look, and what does it mean? And then also think, as I said before, does the registration that I've come across, or registrations, does the other party have reputation or likelihood of reputation, because their rights would be much wider. Yeah. So just to give you an idea of the registration process, I've concentrated there on the UK and the EU, but you file your trademark application. In both countries, in both states now, it's usually examined in about a month, and they'll examine it on the two grounds: is it distinctive, and does it conflict anything with on the register? But in the UK and both the EU, the search they provide is an advisory search. So they won't block you because there's a conflicting mark already on the register. They will then say, if you want to push on, we'll tell the other people about it, and it's up to them if they want to oppose. Once it's accepted, it will be published. So in the UK, the opposition period is 2 months, which can be extended by 1 month, and that's, you might say, where is it published? It used to be published in a physical trademark journal. It used to come out every Friday. Now it's published on the UK IPO website. And you might say, who the hell looks at the UK IPO? Trademark attorneys and lawyers look at the UK IPO website, because we're looking out for anything which is conflicting to our clients. We'll have trademark watch services globally picking up anything similar or identical, and we'll file oppositions or challenge you if you pick up anything. So all the big brand owners will have trademark watches out for conflicting marks. In the EU, the opposition period is 3 months, and that can't be extended. If there is no opposition, then your registration is granted. In most countries, and definitely in the UK and the EU, your registration will last 10 years. But I said it can be vulnerable to cancellation if it's not used for 5 years in the relevant jurisdictions. I then spoke about Brexit there at the end. Brexit used to be a big issue, but basically now if you did have an EU registration, it was automatically split into two, so the UK, but the UK is now very much separate from the European Union trademark system, although we do still follow the same principles of law. So on enforcement, if you've got your registration or you've got your common law rights, just keep an eye out on the market and on the trademark registers for anything conflicting. You can, in theory, put in place trademark watching services. We would charge about £700 a year for a watch globally. And I would literally say for one trademark, I will literally have 20 or 30 notifications coming in every day. I'll scan down through them, hopefully within seconds, and then make a decision whether they're confusing, whether it's confusing goods. And then you can oppose anything, new applications for identical or similar goods if you're not a reputable mark. we will send out cease and desist letters to people if they're conflicting, say pull your application, make an amendment to your application. The other thing is probably most important for you is sometimes filing an application prompts a reaction from a brand owner because they see you filed the application. They may never have been aware of you if you hadn't filed an application, and then I or the brand owner's lawyers will do digging on you and find out are you using, and then you get into infringement claims, etc. And then if necessary, court action. You can, to enforce a trademark, you have to go to court. Only about 2% of any trademark infringement or passing off action will get to a final hearing. They take about a year. A normal action takes about a year. Why do they never get all the way to, usually, to a hearing? Mainly because in legal fees alone, a typical full-scale trademark and passing off action will cost about £500,000 for a big one, and you only ever get 70% of your costs back. And in the US, you get none of your costs back. So just to give you another pop quiz on similarity, do you think fortis and forest would be deemed confusing based on phonetics, visual, conceptual? Would you be confused by them? You've got a no? No? How about vita fit and that slightly stylized vital fit?
Yeah.
Okay. Remember that people slur the ending of trademarks. Also, courts take into account imperfect recollection. You rarely ever see a trademark side by side. How about nef and hef? No. Bauhaus, bow now? No. You don't think any of these are confusing? Red Bull, Red Dog.
That one's definitely.
Okay, it's confusing.
Yeah.
Fortis, forest would be deemed highly similar because phonetically they're practically identical. You lose the T in the middle. The end, the start is the same. The endings are the same. The T is just lost. Also, you scan it and you would miss the T visually. Vital fit, again, would be deemed similar because phonetically they're very close. You lose the L. The other thing is in trademarks of that nature, the court would say the word element is dominant because you wouldn't ring up on the telephone and say, I want the vital fit with that slightly skew-if blue thing. You just say vital fit. Also, nef, hef will probably be deemed dissimilar because the differences are in the start. And I think nef and hef, I think you would pick up the differences. Bauhaus, bow now would probably be deemed dissimilar. Red Bull, Red Dog is a strange one, but I don't think I personally wouldn't be confused by it, but Red Bull are incredibly aggressive about enforcing their rights. Now, where Red Bull might have a case is on reputable mark. You don't have to prove confusion with the reputation. You just have to prove a link, and then that somebody would change, you're trading off their repute, and in some way they would change their behavior. So potentially there could be enough there for at least a reputation argument.
So on the reputation argument, I kind of wanted to ask that. For example, if you create something like Red Bull Bank. Right?
Red Bull Bank, yeah.
Yeah, where it's like a completely different service than the competitor, quote unquote, is offering. So it's not like you're, obviously, if you create like Bauhaus and I create Now House,
yeah,
selling exactly the same goods as they are, then it's disconnected.
No, I think it's okay.
Now that's obviously like me trying to profit off of their goodwill and trying to like be like them and get their customers. But if I am looking at a completely different customer base in a different industry, are they likely to come after me?
Red Bull, yeah.
Oh.
To me, if you had Red Bull Bank, and I would immediately think of Red Bull because it's just such a reputable mark. I think a Coca-Cola of this world could stop use of Coca-Cola on every single goods and services. They do take into account sort of common fields of activity, licensing. So if, like for Coca-Cola, potentially there's the licensing. I think Red Bull would also argue they could bring out a Red Bull computer or a Red Bull. It's just people would naturally assume that licensing is going to happen. It's rarely that you'd have an identical Red Bull bank. You might have a Red Dog. They take into account not only, it's a holistic approach, so it's not just are the marks identical or similar, are the goods or services identical or similar, or are they dissimilar. A court would take into account of everything, but you'd have evidence of use. Have your cells changed? Have Red Bull cells gone down? Are people thinking it's detrimental in some way? A big thing at the start of that test is without due cause. But if I was a judge and you had set up Red Bull Bank, I would if I was Red Bull, I'd get you in the witness box and cross-examine you. Why did you pick Red Bull? Why did you do this? It's just, why didn't you pick something else? I just think you'd have a problem. So don't pick Red Bull, all I would say, and don't pick anything, or easy. To me, Red Bull's an inherently quite a strong mark, but another one who's very, very aggressive is EasyJet. The Easy Group will threaten everybody with Easy in, but Easy, and one of my clients has been threatened by it, and I think they had a good case to defend it. But Easy is not a particularly distinctive mark. So if you put Easy Eats, I don't think you'd necessarily think of EasyJet or Easy Group. Whereas if you said Red Bull Bank, you said Red Bull, it's a much more stronger mark.
Didn't Sky also?
Sky kick, Sky. Sky will threaten everybody with Sky in. So, sometimes with some of these companies, they just want to get a reputation for being hard work. The lawyers will encourage it. I think, hopefully no one acts for Easy Group here, but I think Easy Group have overdone it because everyone gets threatened and it's just not another Easy Group. It was the same with my client. It was just not another one. It's just, and people don't particularly take it serious, and there's a whole raft of decisions with Easy Group that they've lost. So,
and I guess they also take into account what people think about if they are similar or not.
Yeah.
But who runs this analysis on what people think?
Judge.
Only judge.
They will survey evidence. You can have survey evidence in, so they'd sit outside a supermarket and ask little old ladies, are you confused?
Yeah, I guess if people ask
Yeah.
one side or the other, they'll get different responses.
You'll have different experts saying different things, all being paid a lot of money to say different things.
Yeah.
Survey evidence tends to be looked down upon. Judges don't like it because you can't have the questions which are leading. It's very dependent on who you pick to interview. Generally, I would say a judge, there's no juries in these things in the UK. A judge will make their own decision, often probably a gut reaction. Okay, so moving on to designs. So like I said, designs protect the look of a product. In the UK, there is sort of 4 different types of designs. There's protection. There's your standard UK unregistered design right, and that's an unregistered right. That protects shape and configuration. Doesn't protect colors, doesn't protect lines, contours. You then have, because we left the EU, they brought in a new unregistered design right, and remember this is unregistered. You get it when you disclose your product to the public. Supplemental unregistered design right, which covers colors, contours, everything else apart from shape and configuration. Then if you had happened to disclose your design in the EU before 31st of December 2020, you would have a continuing unregistered design right from the community unregistered design right. That lasts up to 3 years. And then finally, you can actually register your design of your product as a registered design. The issue with all of these things is about novelty. So, for example, to get a valid registered design, and the UK IPO will register anything. I could register a cup, I could register that, put in a registration and register that feather over there. they don't examine it on novelty. You won't really know whether it's deemed novel or valid until you enforce it. But what you need to bear in mind is in the UK and the EU, you have a 1-year grace period from you disclosing it to the public to file your design registration. And as I said there, designs unregistered and registered protects the visual appearance of a product. As I said before, UK unregistered design right is restricted to shape and configuration. To enforce it, you need to show that the other side have copied. Independent creation is a defense to unregistered design right infringement. Now, to get unregistered design right, it must be original and not commonplace within the market. It lasts 10 years from first being put on the market. I think it's 15 years from creation if you haven't put it on the market. And then there's quite complicated Brexit provisions about disclosure in the EU and the UK. Also, we've got these new rights, continuing and supplemental and registered design right in the UK, which extends out to surface decoration. Again, you need to prove copying. So if you haven't registered your design, you have to prove someone else has copied it. That could include unconscious copying and conscious copying. So if I got my iPhone out and copied it deliberately, that's deemed conscious copying. But unconscious copying is if you can prove that someone just saw something in passing as part of the design process, you can show that. And it needs to be new and have individual character. Continuing unregistered design right, which is from the EU, pre-Brexit, that lasts 3 years from when it was disclosed, and it's 10 years from first disclosure on the supplemental UK unregistered design right. But to get supplemental and UK normal unregistered design right, you have to make first disclosure in the UK. So if you're disclosing it in the European Union or abroad, and you haven't done, that's not, that is the first disclosure. You will have no UK unregistered design right. So what I'm saying there is consider where you're going to disclose your design. And what you might want to consider particularly, you could do simultaneous disclosure online, globally, and you might then get over these disclosure rules to get your protection. Just to give you some horror stories of where it all goes wrong. So registered, both UK and community registered designs protect shape, configuration, color, surface decoration. Again, like I said, there's no formal examination, but it has to be new and have individual character. New means it's not identical to something which gone before. Individual character means it doesn't give a same overall impression to what's gone before. You've got a 1-year grace period from launch, and it lasts up to a maximum of 25 years, and you renew it every 5 years. So in contrast to trademarks, which can be renewed forever. So for example, Coca-Cola have registered since 1895. I've got clients who've had registrations for 100 years. You can only, design registrations only last a maximum of 25 years. And good images are vital. Now, the two horror stories there is the first one about self-disclosure. That's the Crocs shoe. Crocs shoe was originally not deemed or designed to be a fashion item. I don't think it is. A lot of people would say it's not a fashion item now. What it was originally designed for was to be on a boat. So it would stop you slipping on a yacht. And when they first launched the product, they disclosed it at a boat show in Florida. Quite a restricted boat show, but it was a boat show in Florida. Crocs took off as a fashion item. They didn't bother to register it. They went off and registered it in the European Union 2 years after it was disclosed in the yacht show. They went round enforcing it, and someone cancelled it because they said they disclosed it beyond the 1-year grace period. And Crocs said no one was looking at that boat show in Florida 2, 3, 4 years ago. And the judge said it was on the internet, that's worldwide disclosure. Crocs have not got a registration for their main Crocs shoe. So when you're thinking about your design and disclosing it, just remember that 1-year grace period. In lots of countries, so for example, China, etc., there isn't a grace period. So as soon as you disclose it and you haven't registered it, you've self-disclosed. There's questions over disclosure with regards to talking to suppliers, talking to investors. So if you do like a confidentiality agreement, or if you make sure, you don't necessarily need to have it in writing, but you make sure when you're making those discussions that this is a confidential discussion, that's not self-disclosure. So just be wary of that. The other horror show there is the Trunky. Trunky filed their own design registration. They didn't use a design attorney or a lawyer, and they registered it in that CAD/CAM drawing. The main thing about Trunky is the shape. What do you think is the problem with that registration, that CAD/CAM drawing? What does it include as well as the shape?
Do you have objects in the room?
Yeah, well, it includes the difference in the color tone between the wheels and so there's darker there and there's lighter on the main thing. What happened is when Trunky took off, a whole load of Chinese counterfeiters came out with very similar Trunky things. Trunky originally, they took the Chinese infringer there to court. They won at the High Court. They then lost at the Court of Appeal because what the judge said is that's not only a registration of the shape, it's a registration of the color and the shape. And if you look at the Chinese infringer, not only does he have the shape, he's using a completely different color design. And the Court of Appeal found against Trunky. It went to the Supreme Court. The judges were really down on, they thought it was awful for Trunky, but they found against them. And they found that the Chinese infringer didn't infringe that registration because they were using a different color. And you just need, when you're registering your designs, it's probably best not to use CAD/CAM. The Design Council got involved and said every designer's using CAD/CAM drawings. I think a lot of attorneys probably said, yeah, you filed it yourself, but we probably would have filed it like that. But just use like line drawings and just think when you're registering a design, what is the important design element? Is it the color? Is it the shape? Is it the combination? And when you file a design application, you can file all those in multiple forms. So just think about what you're actually trying to protect and probably talk to, designs are very easy to file, but they're very, very easy to get wrong. So probably talk to a lawyer or an attorney. Again, with enforcement, just monitor what designs are out on the market if you get your registration or if you've got unregistered design right, what your competitors are doing. The infringement test is, does it give the same overall impression? That will be dependent on what is in the prior art. Are there lots of similar designs on the market? The judge creates a mythical person called the informed user to make that test. The informed user is not a consumer, has no idea of the design corpus. They're also not a designer who has complete knowledge of the whole design field because a designer will pick up very small differences. It's someone in between. It's usually probably a buyer, someone who has a bit of design knowledge but not tons. And also with designs, a natural response on design right and on registered design is you always challenge the validity if you're the defendant. So if you think about fashion designs, fashion tends to recycle. And we had a case where one of our clients was threatened by, I think it was LK Bennett, who had a registration of a design of a dress which was made well known by the Duchess of Cambridge. And we thought that the registration was probably invalid because it took things from the 1930s, 1920s. So you can invalidate things based on lack of novelty, but it costs you money, and our client just decided they couldn't be bothered and they stopped using the dress. And also you need to be aware of this squeeze argument before. So if your design needs to be sufficiently distinctive from the prior art, and the infringer needs to be closer to you than the prior art, because otherwise you get into a squeeze argument with invalidity. Just to give you an idea of a big case on design, my firm's biggest client is Samsung. I don't do trademark work for them, but we do a lot of patent work for them, so I'm never going to be able to act for Apple. But Samsung and Apple are constantly each other's throat, and a big case was on the iPad. So obviously Apple brought out the iPad, very clean look and design, and Samsung brought out a different, well, a different design, but just talking about validity, so Apple had this design registration, and Samsung's main defense, we weren't acting for Samsung in this case, but Samsung's main defense was validity. So you look at the prior art, and one of the things Samsung brought up was the Etch-a-Sketch toy from the 1980s and said it looks quite like an iPad. And that was actually quite a good argument, because when you're thinking about validity of designs, you have to look at everything. To give you another example of where that was brought up was a guy, you know those little balls you stick into washing machines to stop the static building up in your washing? A guy thought, well, that's a good idea for a pet, for a dog toy. And a design registration and your unregistered design will protect that look for all goods. And basically the person who'd had the anti-static look was successful against the pet ball guy, because it was the same, all the same. You take into account all goods and services. And then third one, we've got copyright. So copyright is an unregistered right. It is created as soon as you create an original work. You don't need to register it. So as soon as you create this product, this work, and that might be literary, music, dramatic, artistic, put it in writing, it only protects you stops other people copying. So if someone comes up with a new work completely independently, you can't stop them. And infringement is held when you reproduce a substantial part of the work. Now, to give you an idea, Dan Brown, it was very big, was it 10 years ago, the Da Vinci Code? The Da Vinci Code, there is actually the Da Vinci Code is based on the main premise that Jesus Christ had a daughter, and then it fed through into history. An academic sued Dan Brown, tried to claim damages for all his books based on that Dan Brown had taken the idea and created it into a fictional work. And this is the dichotomy between, they call it the copyright dichotomy, and it applies to all IP. IP doesn't protect an idea, it protects an expression of an idea. So Dan Brown was successful in the defense because he said he created from that basic tenet a new work, a new fictional work. So he stopped the person trying to enforce their right. But one thing which has slightly mucked up that very pretty dichotomy and pretty sort of test is here, those two works. This is, if you go to London, you'll see them. They put sort of well-known tourist landmarks behind them and put a red bus on them. They were deemed to be similar because they effectively had a similar idea, and that slightly mucked up this copyright defense. But you do have defenses for non-commercial fair dealing. So if you're doing it for academic or private study, for journalism, criticism, there's also things about parody defenses, and also for review and quotations, because that's to stop people using copyright to impinge on free speech. Finally, patents. I'm not going to talk a hell of a lot about patents, but they protect technical functions, must involve a financial and inventive step, and you can obviously use patents to stop other people using this, the same technology. Again, with designs, patents, and copyright. Copyright lasts 70 years from the death of the author. Patents last 25 years. Designs last 25 years. They all have a finite period. And so with a patent, the deal with the government is you put in your invention, you get it granted, and it gets published. It goes out into the world, and you will get your 25 years after while you pay your renewal fees. But you need to make a decision there whether you're going to do that deal, because I don't know if you ever see in the financial press, particularly on pharmaceuticals, they say we're going off a patent cliff, because they will have their pharmaceutical product patented for 25 years, and then as soon as it comes off patent, the generics will come in and copy it because they can see it in the patent application or registration. To give you an idea who someone didn't patent is Coca-Cola. Coca-Cola never patented the recipe for the Coca-Cola. It's locked up in a safe in Atlanta. I've been to the Coca-Cola Museum, claims that only 3 or 4 people know about it, but they made a decision they weren't going to patent it because they didn't want this 25 years finite period, and they've just kept it secret. So that's another way you can avoid, if you want to. But the problem is, if someone ever did successfully, I think Virgin tried it, everyone's tried to back engineer a Coca-Cola to make it taste the same, and they never really succeeded. But if they ever do, Coca-Cola won't have a leg to stand on. So they took a decision not to go down the patent route. They just wanted to keep it secret. So that's it. If anyone has any questions about IP.
How does that work in terms of like Coca-Cola having to put the ingredients on the label?
I think there's probably, they would say probably how they make it and how they temperatures and
I think there's one with like natural flavourings, it says.
Yeah.
It doesn't say what these natural flavourings are.
yeah.
That might be the secret.
I know your specialties,
Yeah.
patents or that, but broad strokes, what about code? What in everything that you presented today applies to code?
Code special. In most countries, in the UK and the EU, it's not possible to protect computer code as a patent. It's an excluded form. There may be means and ways around it, but what code is generally, in the US, it's slightly easier. I'm not an electronics patent specialist, but code is protected by copyright. So if someone's copying your code, your code is a literary work. This is why I go into, copyrights, you think it's books and it's lovely paintings and it's that thing on the back of the room. It's terms and conditions, it's computer code, it's any combination of words. There was the SO case held that you can't have copyright in one word, because SO not only registered it as a trademark, they also tried to claim copyright in SO, because they said, oh, so much effort has gone into making SO. But the court, I said that they all slightly overlap, all these rights, but judges like to put it in boxes. So that's a brand, that's trademarks, that's a design, that's how it looks, that's a copyright, that's an artistic work, that's a design. But they do overlap slightly, but with copyright, it's probably a combination of things. But I just want to get across with copyright, it can protect lots of things you wouldn't think are protectable.
And you don't have to register that. Sorry.
No, you don't have to register copyright. It might help in China, it helps to register copyright, because although China's in the Berne Convention and should in theory enforce unregistered copyright, they don't. And Chinese, you look at China and you think it's the wild east, it's termed, but if you get registrations there, they will enforce them. Like we've got police to go in and smash factories up and things like that. So they will do it and they will enforce it. But yeah.
That's public then.
Yeah. So, yeah.
So what about like a model of education? Could you?
This is the problem with this dichotomy in IP between an idea, a concept, and an expression of an idea. So if you've got a model of education where you would have, and it's like, I would also make the analogy to a restaurant, a look. So you would protect it probably through copyright, through the literary works, through putting it on paper and how you're going to do it. Probably via designs as well, the colors. So for example, Apple would probably have copyright in the look of their stores. They've also registered it as a trademark. But there's all problems with definition. But what I'm trying to get across is IP doesn't protect an idea or a concept. You have to put it on paper and you have to define it very clearly. So there would be means and ways of protecting probably a concept of an educational,
Thank you.
How does it work in terms of like translations into different languages for like trademarks of a particular like brand name or something?
It will depend on the language and whether consumers are confused. To give you an example, I act for BFS, and you probably never heard of BFS, but if you see their lorries everywhere, they're called Bid Food, and you see their lorries with the foodscapes on. Looks like bread and everything. They're the biggest food service group in the UK. I don't know if you've ever been in a service station, but if you see Coronet, it's like those milk sachets. They're everywhere. Well, anyway, they filed a EU trademark application for Coronet, and they were opposed, I think, by Philip Morris based on a Latvian registration for Karuna. Now, do you think Karuna and Coronet are similar? Well, literally, Coronet means small crown in English. In Latvian, Karuna means small crown. So they argue that conceptually they were similar. But I would argue so say for example, in the UK, French, German, Spanish is relatively understood and sort of understood. I think, I don't speak French, even I would know bonjour or je m'appelle. So if people make that mental link to the other brand, but if you're talking about Vietnamese, and it's an obscure word, then you're not going to be able to show confusion. There's issues with Chinese in transliteration. In China, issues with, just to give you an example, and I'm slightly going off piece, Chinese consumers tend to give brands nicknames. So Quaker Oats is grey old man, apparently, in Chinese, that's what they call it. And I don't think, there's an example of Siemens didn't register their nickname, then tried to enforce the Latin script of Siemens against the nickname and lost. So, and there's all issues with, I think if people make a link, then there's a potential for confusion, so. Is there any other questions? Don't you have had a question behind? No? Yeah.
On patents as well.
Yeah.
Can you patent the process? So instead of the code itself, the process that
you mean a business process patent? Again.
Yeah, but if you were to apply that to the code bits, if you're writing code and it's processing or data or it's doing something and there's a specific process behind
like an algorithm.
I'm going beyond my expertise on patents. I would say a good patent attorney will be able to manipulate, because when you file your patent, you have to make a claim. They will be able to manipulate the claim in such a way to potentially catch what you want to stop. And that's why you pay a patent attorney a lot of money to do it. So they will think about, and like a trademark attorney will think about, when you're registering your brand, you have to think about what you're going to use it on, what you're likely to use it on, and what your competitors are going to use it on. And you go as wide as you can to try and stop other people using it. So. But that is, I know someone who knows a lot about it, but it's not me, so, yeah. Okay. All right.
In terms of trademarks, with the place name and the business name after that, with competitors with a similarity, can the place name be stronger? Because I know it is an argument.
If, depends on the place name. So, for example, you couldn't register Manchester, London, Liverpool, because there's so many people in those cities, and the basic test from European law, and it's in UK law, is it well known, associated with that place? So probably London gin, something like that, or is it likely to be manufactured there? And in the example, and I think you're getting at, the less distinctive a mark, the less likely they are to be deemed confused. So for marks which have a geographical place name in, a descriptive term in them, small differences are deemed to be enough to distinguish them. And there's a well-known case called Westminster window cleaning, where the judge said, you're a bit stupid picking Westminster window cleaning because it's quite descriptive. So somebody else had small differences, and that was enough. But what I'm trying to say also, as I said before, the law isn't there to protect morons running around the supermarket in a hurry. You have to be certainly circumspect. But I have used your argument and won that weak marks are inherently problematic to enforce. In a perfect world, you want an invented term or very distinctive term. So
I think the time there was a similar alphabet. There's a Budweiser and then the Bud Bar.
Yeah. Well, that was, that went on for decades. And they attacked each other for decades. So, yeah, because Budvar is a place, I think, yeah.
We still lost. So.
Yeah.
In the Czech Republic.
Yeah. Well, Budvar tastes much better than Budweiser, I think. So,
You have a support in it.
yeah.
Awesome. Thank you so much.
Great, that's fine.
Really appreciate it.